Welcome back on the AM show. Time now for us to get into our big stories. And the minority is set to boycott parliamentary sittings in solidarity with their leader, Dr. Cassio Atoforsen, who is standing trial for alleged impropriety in the procurement of ambulances. Now, they say the presiding judge, Justice Ifiasewa Asariboche, has on 2 occasions denied their leader leave to carry out his official parliamentary duties and that the court must do what is needed. But is the minority justified in taking this stance, in adopting this stance? And are there implications for government business? What's the way forward? How do we delve into the issues? Well, joining us, we have Bobby Banson. He's a lawyer. He joins the conversation. We also have in the studio Peter Nochu Koto. He is a member of Parliament, of course, and he is a member of the Education Committee of Parliament. He'll be joining us on thoughts in respect of the minority's position, and later on the next belt, also delve into the educational matters. Bobby Banson, a very good morning to you. Bobby, can you hear me? If you may have to unmute. All right. Bobby Banson, we'll try to get back to you. I think the internet connectivity is a bit patchy. But what has happened? What has brought us here? The minority in Parliament is saying that time and again they feel disgruntled about some of the approaches adopted by the court in respect of their leader, Dr. Cassio Atoforsen. Twice he's requested leave to deal with official business. He's not been granted such leave, and they feel it is impeding their work and also impeding their position in Parliament. And as of yesterday, they made it clear. A number of them thronged the court, and they made it clear that if this continues, then every time the minority leader is in court, they will boycott till he is back from court. There's also the issue of the admissibility of some recordings that the third accused, A3, Richard Jakpa, wants to be aired in open court. Yesterday, the Attorney General himself, Godfrey Yeboah, was not in court. The Deputy, Alfred Tuah Yeboah, was there together with Isaac Wilberforce Mensah, and they shared some thoughts on that. Let's connect with Bobby Banson. He's a lawyer. Bobby, good morning.
Good morning. Good morning. Sorry about the Zoom connection, but I hope you can hear me now.
I can hear you loud and clear. Zoom no mfane ho. Yebekasa. Ewa ho microphone so. So let's get into it. First off, your appreciation of happenings in court yesterday and then the accusations leveled by the minority. But let's start with what was discussed in court yesterday in respect of the tape, its admissibility or otherwise. We know tomorrow the judge will rule on that. What's your thinking on it?
Well, I think that it's an interesting legal development considering, one, the stage that they are seeking to admit this document. Every lawyer will tell you that the test for admissibility is relevant. Beyond the relevance, you would have to weigh the exceptions provided under our evidence law, that every evidence before it to be admitted must be relevant. But it doesn't end there. Even relevant evidence may be excluded by the court if the court is of the opinion that the weight of the relevance is overweighed by other considerations, such as unfair prejudice, unnecessary delay, to scandalize the parties, and then the law list provides them. So I believe that is what would weigh on the mind of the judge. There's also the other aspect of the general provision or position that if you record somebody without the person's consent,
right,
that evidence may not be admitted on the basis that it's a breach of the person's constitutional right to privacy. However, we will see that over time, there have been exceptions in the Ghanaian jurisprudence concerning the admissibility of that evidence when that evidence would lead to a criminal charge or is in pursuant of a criminal allegation against the party. So the judge would situate the exceptions in the context of the general provision of the Evidence Act, and they determine whether it is relevant, if they're relevant to the charges that have been leveled against the accused person.
Right.
If it is relevant, whether the relevance would be overweighed by the other considerations of constitutionality or unfair prejudice, or whether it will lead to undue delay considering the stage that they are seeking to admit this evidence.
Right.
So I believe that should be weighed by these things.
All right. So, I mean, in her shoes, these are some of the things based on the face of the law. These are some of the considerations you would be adopting. And like you rightly said, in the past, our jurisprudence has pointed to the fact that the admissibility probably would be in question. But some of the latest rulings on some of these matters have also admitted some of them on the back of maybe the consequence of what not admitting them would bring to bear. But do you think it makes any difference in terms of the admissibility? Do you think it makes any difference? It adds any weight? The caliber of people involved, the AG on the one end and the minority leader on the other end, could that affect the decision of the judge in this matter in any way? Because of, like you said, consequence is of consequence. Could it affect anything?
You know, this judge, Justice Ifya, has demonstrated that she is no respecter of persons.
That's what we hear. I mean, she's no nonsense.
Yes, I mean, like I've said, those who saw her when she was in practice, and I had the privilege of experiencing some of her work in practice in Kumasi when I started work, the same attitude she has carried into the bench. And so irrespective of who is involved, she is going to dispense justice according to her appreciation without any fear or influence or any consideration of the personalities involved. So I have no doubt that she is going to deliver a ruling according to her appreciation of the law, and then whoever or however it goes, she will stand by it and will be able to justify it.
Now, we know that the audio recording was admitted. It formed the basis of the trial judge's 6th June 2024 ruling on a mistrial, among others. Of course, she didn't grant that position for a mistrial. But you listen to your colleague, Aziz Bamba, lead counsel for Dr. Kasialato Forson, and he says that the telephone conversation hinged largely on the agreement between the government of Ghana and the letter of credit that was subsequently issued, making the recording an important piece in the ongoing trial. He also argues that the AG's posturing in the audio recording constitutes willful, and I'm focusing on the words intentionally, willful oppression of an accused, and that it is not the Attorney General's place to be giving theories to an accused person in an ongoing trial. Then he tops up with his own objection, saying the audio is relevant because it shows that the case hasn't been mounted in good faith. If you listen to the language of Aziz Bamba, what do you make of it and his objection?
I mean, he's a very respected lawyer who has so many years of experience. I believe that he would have legal basis to present the argument the way he has presented. I believe that the Attorney General has also fought back with his opposition. Let's leave it for the judge to make a determination of it. I always say that no matter how sliced you cut a bread, there will be two sides of it. And so the beauty of the law is whatever position you take, if you are diligent enough, you'll be able to provide legal basis for it, unless, of course, it's completely unsupported. And so I believe that Dr. Bamba has supported his position with legal authority, and the AG has opposed also with legal authority. That is why there's the judge. Let's see how the judge will take it from there.
Hold for me, Bobby Banton, and of course, talking about the no-nonsense constitution of this lawyer, I mean, for the first time, asking an AG to recuse himself, advising him. I mean, that in itself pointed to something never before heard. But let me bring in Samuel Bing. He is with the Parliamentary Network Africa. Sami, good morning.
Good morning.
It's really good to have you. Where have you been hiding? We've not spoken in a while.
Yes, we haven't. Always a pleasure to be on your platform.
It's good to have you. I also want to address this conversation from the standpoint of the minority, saying, listen, if you're not going to grant leave to our leader to do official business, then we are also going to move away from Parliament. Whenever he comes back, we'll be in Parliament. But as long as he's in court, we'll not be there. What is your reflection on this positioning of the minority?
Well, reflecting on it, it's appears to me that this is a strategy the minority had experimented about a year ago in the Jakpa case. And they appear to see or note that it got them some results so far as, being in the limelight is concerned. And because of that, they feel there is no need changing the winning strategy. And that is why now that it involves the leader of the caucus, they are even looking forward to escalating it. But remember that when this happened in the Jakpa case, there were a couple of issues that came up with it. The first was that on a few occasions, it seriously disrupted the business in Parliament, to the extent that it got the Speaker of Parliament complaining and lamenting, and actually warning that if members of the minority caucus would not resort to the lay-down procedures in Parliament, which is to officially request permission to be absent, then he is going to start applying the rules in Parliament as relates to being consistently absent in the House. Now, Parliament itself, has it learned the lessons from that particular period and has it put in place measures to mitigate it this time around? I'm not too sure about that because of how the last situation ended. Has the minority learned lessons from the last situation and put in place measures? Yes, I think that they are of the opinion that this worked for them to perfection in the last time they applied it, and so are willing to apply it again. Have we as Ghanaians, learned lessons from this and, shown our political leaders that we expect more from them than some of these things that they do? I do not think so. Because you see, we are over 30 million. All of us cannot be in the hallowed chamber of Parliament. It is the very reason why we elect representatives. So if you do an average, we are looking at each person, a member of Parliament, representing about 100,000 Ghanaians. Anytime he or she is not in Parliament, those 100,000 Ghanaians who he or she is representing do not get representation. And so it is, for me, a bit of a problem if members of Parliament prioritize some of these things against the representative function that they are supposed to play in Parliament. And it behoves on us as members of the public to call our MPs out when they do these things and to let them know that their foremost responsibility and allegiance is towards ensuring that those of us who have given them our mandate in this agent-principal relationship would be respected.
Now tell me, how could this possibly affect the work of Parliament? We know that government business has suffered. I mean, when the Ejisu by-election was yet to be held, different deliberations. Is this going to affect government business, this posturing of the minority?
Give or take, the 8th Parliament of Ghana has less than 12 weeks to end its tenure. 12 weeks of sittings to end its tenure. In this current meeting, they are sitting from now until about the end of July, which is about 6 weeks. They go on a recess, come back and do about 4 weeks, 5 weeks, maximum 6 weeks again, and then they break for elections completely, right? What it means is that all the bills that are in Parliament, affirmative action bill, the bills relating to tree crop development, the bills relating to there are many other bills that relate to the interest of the Ghanaian people. So many of them, which will take a lot of time to be able to go through and pass, are still hanging. We know that there are other government businesses that need to be executed. Any time that the minority out of Parliament, the experience of last year shows that it affected the extent to which business is able to take. Yesterday, one will argue that this boycott is not really affect the proceedings.
Sam, please reposition yourself just a little for me. The line is breaking a bit.
Is it better now?
Better. Please go ahead.
Great. Yesterday, one can argue that it did not necessarily affect the proceedings in Parliament because at the time that the sittings began, they had already come back to chamber and they joined in the proceedings. But this is not going to be the same situation. And this becomes even more serious when your reporters in court observe that they did not find 137 minority MPs in court. What it means is that the minority could still make that same statement by getting a delegation that represents them in court and also ensuring that the work of the people of Ghana that needs to be done gets done. So that is it when it comes to the government business. But remember that Parliament is not only about government business. There is also what we call private business in Parliament, and this has to do with specific issues that affect specific constituencies represented by specific individuals. So, for example, there is question time when an MP asks a Minister of State a question relating to development situations in their constituency. So let's say I live in the Adenta constituency. The MP here asked about the construction on that road, which has been problematic all this while, the Adenta-Dodowa road. Yet on the day that the minister comes to answer the question, the MP is not in Parliament. What happens in parliamentary procedure is that the minister will not answer that question. He would consider the written answer that he brought, a short written answer, as satisfactory, of addressing the matter. And it will be those of us within that particular constituency who would suffer. And we saw that many of such instances happened during the Jakpa boycott situation. We cannot have our interests as constituents sacrificed on the altar of, people seeking the interest of their political party, despite the fact that they have every right to solidarize with their leader, but they must know that their right ends also at the point where we have the right for them to represent us as our elected representatives.
Sammy, I know you're pressed for time. I just want you to do me this courtesy this morning. I want Peter Nochukoto, who's in the studio and speaking for the minority, to just reflect on the justification for this action of theirs so that if you have any final reaction, you can give it before you go. Is that okay?
It's tough, but let's go.
All right. Peter Nochukoto, I want you to be brief because he has to go. What justifies the stance of the minority to say you're going to boycott Parliament because of this?
Yeah, thank you very much, and good morning to your viewers. Yeah, the issue is that in Parliament we have leadership, and our leader is Dr. Atufossin. If you are preventing him from doing his constitutional duties, then if the leader is not there, what as members do we go there to do? Why is he being persecuted in court?
But when the leader is not there, there are deputies who can stand in for him.
Yeah, but he has some constitutional duty to perform. And we are saying that allow him time to do his work. Then,
but let me ask you just quickly. So if the leader were indisposed, assuming he was sick, right? He couldn't make it to Parliament. Would your deputies not step in?
Yeah, they can, but this is a different issue altogether. By just consensus, the judge can allow him to do his constitutional duty, then later on he goes to court. So if you want to prevent him from doing his duty to the nation, then as members of Parliament, we feel that our leadership or our leader is being persecuted, and we must make sure that we give him that moral support. We are not saying we won't come to Parliament. Anytime he's attending to court, we will follow him to court. When the court
yes, but the instance has been shown that it's not all 137 of you who are in court.
It doesn't matter. Like yesterday, some were in court, some of us were in the house, not the chamber, when we were having the press conference. So that was what we did. And don't be surprised.
But reflecting on what Samuel Obeng says, that listen, every MP is representing about 100,000 plus people. If you just do the divisions, though it's technically not the same.
Yeah.
Each time a member of Parliament from a constituency is not there, it has an impact. Why would you want to do this? And how it will affect government business?
We want Ghanaians to know that what is being done to our leader is just a calculated attempt to cow him and then jail him for what he has not done. Do you see it? So we will continue to support him. Anytime he's going to court, we will follow him. Even if it is only 5 members who are there, they represent us. And what we are telling Parliament or Speaker is that, well, when it is even 3 o'clock and the court session is over, we'll come back. Like yesterday, Parliament, for the first day of a sitting, we went to court. When he came back, Parliament sat, we closed around 6 p.m. yesterday. So we'll still be doing business. The reason for which they have elected us will be there.
Okay.
So we'll make sure that we follow our leader to court.
All right. Thank you. Thank you very much. Let me also bring in Sami Obeng, who is with the Parliamentary Network Africa. Sami, any quick reactions, reflections on what Peter Nochukoto has said, and then you can go.
Yes. So first of all, there is good reason why this whole perennial, repeated situation of Parliament judicial relations and the issue of MP standing trials, arrest of members of Parliament and all of that needs to be dealt with inclusively. And we need to have a proper conversation about this and find a way around it. But yes, when members of Parliament need to perform their responsibility and to our neighbors that was caught, the same principle I raised about the number of issues they represent who would not represent that.
Sami, just move a bit. Just move a bit. We're losing you again. Just move a bit.
Yes. So I was saying that the same principle of the number of Ghanaians who gets represented, who must be represented, who do not get represented because their member of Parliament is not around, also applies if a member of Parliament is facing trial, during periods when Parliament is sitting. So that particular conversation we need to have. However, the fact that one member of Parliament is facing that situation does not mean that all of us, all else, should not be represented because of that. And members of Parliament in the minority caucus or wherever who make this explanation about, leader not being around and so they cannot be around must know that we as Ghanaians, to a greater extent, understand the proceedings in Parliament, both houses go. And so some of these reasons that get given really are really, and to the extent that Parliament feels when the man who's supposed to decide is not around, means that for Parliament then is that it can go on without the people.
Okay. Sami Obeng, we're so grateful. Thank you so much for, I know I've eaten into your time for other matters, but thank you so much for indulging me. Sami Obeng is with the Parliamentary Network Africa. Bobby Banton, before I come back into the studio, Bobby, I'd like to find out, so I don't know whether you have a take on, that is not a legal matter, the minority's decision to step aside every time the leader is in court. But the substantive question to you is this going to be another test for the law, another test for Ghanaian jurisprudence? And are you hoping, from the academic standpoint, that this is going to give further clarity to how to deal with some of these issues in terms of the admissibility of evidence, such recordings? What's your take?
Yes, I expect the judge to give a very well-reasoned opinion or decision that will serve as a guide to subsequent issues of this nature when they come up. Because I suspect that, like she has done in all her rulings, particularly the recent one, she gives the historical antecedents of how the law developed in respect of that subject area. So I'm sure she'll go down to the Kuba cases and then come down to the settings and then give her conclusion on this. And it should be good learning for everybody who is interested in this area of the law.
All right. And in respect of, like I asked earlier, in respect of the minority's positioning, what's your take?
Them boycotting the court. It's not, I don't think it's in the interest of the state for political parties to use such avenues to boycott parliamentary proceedings. Because if you do that, like Mr. Obeng said, it is the citizens who voted for you that will lose. One, I don't see the impact of the boycott on the proceedings. The judge will not be influenced by the solidarity that you have allegedly offered. It will not have any impact on the evidence that has been adduced or the law as it stands which will be applied. So the question for me is, what then is the end game? Are you trying to seek attention for an already politicized or publicized matter? Or are you using an avenue just to not show up in Parliament? And it's because of the over-politicization, because then it is becoming NPP versus NDP in court, when it's actually not. So whichever side decides to do this, and I've always wondered what the end game is. It is not as if you are protesting something that has happened in Parliament, for you to say maybe the speaker was unfair or something for which you say you are boycotting proceedings. This is something that is happening outside Parliament to one member who has legal representation, who are, fashioning out his defense. And so, you boycotting parliamentary proceedings in solidarity, I think it may backfire, because if what you want is to seek sympathy from the judge, so that the judge would manage the case or the hearing to suit the parliamentary timing, I don't know if boycotting parliament would have that impact on this particular time.
Just a quick top up, and you can go, I beg of you. So this bit about the lawyer for Casilato Forson saying that the trial judge, it skipped my mind, has been unfair by not granting him leave to perform his official duties. What do you make of it? I don't know whether you firmly reflected on that. I just want a quick thought on that.
The unfair, I think, is a strong word. It's exercise of their discretion. And unless
by saying that, you also mean someone else could have exercised the discretion the other way.
Yeah, but that is why it is called discretion. You cannot force, there's no judicial prisoner when it comes to exercise of discretion, unless there are certain principles of law that would govern the exercise of that particular discretion, in line with maybe Article 296 or 23 of the Constitution. But if she thinks that this case has dragged on, she thinks that it will be in the interest of justice, all the parties involved. Because remember, it is not only Mr. Atuforsi who is facing trial. There are other accused persons as well.
Yes, but some of the tapes also reveal some, and there have been allegations of the fact that, those people were only added because they were going to be collateral damage. All of that is also in there, so it makes.
No, I'm not speaking about the admissibility of the tape. I thought we're discussing her decision not to adjourn the trial to suit parliamentary timing.
Yes, I get that. That is it.
Yes, so that's what I'm saying. That I will not. It's her discretion. There are some judges that may do that, but if she thinks that she wants to finish this within a certain time, as it were, or there are other interest holders whose interest at this point in time may override that of a single accused person, you can't say that she has not considered relevant principles that govern the exercise of discretion in that matter. So if they appeal to her and she thinks that she wants to do that, nothing will stop her. But if she decides not to do that as well, I don't think that you can say that any miscarriage of justice will occasion Mr. Atuforsi, that because of that he's not able to present his defense, as it were.
Bobby, thank you so much for being a part of our morning on the AM show. That is Bobby Banton, a lawyer. He joined the conversation. Before we move on to the next conversation, any final words, Peter Nochukoto, on this one?
Just want to add that our decision to stay away from proceedings whenever our leader goes to court is not to stampede parliamentary business, but for the public to know that what is happening is a calculated attempt against our leader. And for that matter, we'll be in solidarity with him.
All right. So